Okay, so I have 3 articles for you today, all from The Advocate. The first one is an update to a story that I might have done a couple of videos on this story. And then we have 2 new ones, all on the legal front. So let's start with the first one. Florida teacher fired for using student's nickname won't get her job back. So that's awesome. A Florida teacher can still work in the classroom despite her willingness to call a student by a nickname, but it won't be with her former school district. Okay, fair. Now, this is where things get insane. I do not care what that nickname is. We are now waging a war against nicknames. How absolutely insane is that? The Florida Education Practices Commission upheld a settlement between Satellite High teacher Melissa Calhoun months after a parent accused the educator of grooming her daughter to transition and to be gay. Which I'm sure in her bigoted mind is the same thing. But it's not. Either you're trans or you're gay. I mean, you can be both. But unless this mother is saying that she would still like guys, but she would also be a guy, I'm not sure where she's getting the idea that she's being groomed to transition and to be gay. I mean, that could be it. That could be the thing. Or maybe there's another surprise awaiting this parent. But anyway, you don't groom someone to transition. Kids know what gender they are. It's amazing to me how a kid who accepts, who identifies as the gender they were born with, the sex they were born as, nobody questions that they know. But somehow being trans, oh, no, you couldn't possibly know that. So this teacher is not grooming anybody not to be trans and not to be gay. This is not how anything works. Anyway, Calhoun, who told administrators she did not know the student's preferred male nickname was an issue or that using it violated the state's infamous Don't Say Gay law, agreed to pay a $750 fine to the state and take an ethics course, according to Orlando's NBC affiliate. The settlement allowed her to keep her teaching certificate and avoid being fired by the school district. She might probably take that ethics course the way speeders go to dum-dum school. It's just, okay, we're going there, we're gonna, just go through the motions, but completely ignore all the bullshit. And it's true. She actually, in a previous article that I read and video that I did, she did mention that once she found out that this was a problem, she told the student that she can no longer use their preferred name, their preferred nickname. So it's true that she was trying to follow the rule. Whether she thought it was bullshit or not. Sounds like she thought it was bullshit, but regardless, she was trying to follow the law. It's just that she did not know that this was part of the law until too late. And, let's just pour one out for that poor kid who has to live with a mother who, basically hates her kid. Because if you're going to blame a student's teacher for her transitioning or for her being gay, which, one or both of those could be true, but if you're accusing the teacher of that, the child knows that they are not safe with this parent because they cannot be their true selves. So, yeah, definitely a sad time for that child. However, Brevard Public Schools Superintendent Mark Rendell said Calhoun's past contract expired and she will not be rehired by the school district. Probably for the best. I don't know, because apparently it was just this one teacher, but the school district went with it, so I don't know. While the state has chosen to allow this individual to retain their certification under probation, I believe it is appropriate that the full term of that probation will be completed before any consideration of employment, he said in an emailed statement to Florida Today. The teacher applied for a job at the district the day after the state commission approved her settlement. The school year in Brevard County begins on August 11th. Okay, I'm confused. So, is she going to be rehired or not? Or is Brevard a different school district? I don't know. It's not clear. Okay. Calhoun's agreement became controversial when Governor Ron DeSantis' newly named Education Commissioner, Anastasios Kamutsas, I'll get it, said he wanted the state to back out of it. No reason given as to why. Calhoun was the first Florida teacher who faced termination for violating the state's law, which bars any instruction in public schools about gender identity or sexual orientation. The local teachers union in Calhoun School District welcomed the decision by the Education Practices Commission to uphold the settlement agreement the teacher reached with the state. This is an important victory, not only for Mrs. Calhoun, but for the thousands of students whose lives she has touched throughout her career, read a statement from Brevard Federation of Teachers President Anthony Colucci. With nearly flawless evaluation spanning more than a decade, Ms. Calhoun has consistently exemplified the dedication and excellence that Brevard County's children deserve in their classrooms. The Brevard County School Board now has the opportunity to rehire a beloved teacher who has gone above and beyond for her students. We urge them to act swiftly and justified to return Ms. Calhoun to the classroom where she belongs. So, I don't know why we had a sentence that said that she wouldn't be rehired by her former school district, where they're saying that she will be. So, maybe whoever wrote this accidentally wrote school district and meant just the specific school. Because that would make sense. That would make sense with the rest of this article. Alright, so that is the end of that article. I assume before I get to the next one, I assume that the new education commissioner had wanted to back out because I guess he wanted to be a hard ass. And, oh, she, actually treats trans people like human beings, so she's going to always do that. So why don't we just, punish her, or something. Okay. Sorry, I have an itchy nose. All right, so let's move on from Florida to Massachusetts. Massachusetts Governor Maura Healey signs abortion and gender-affirming care shield law. All right. Massachusetts has enacted an even stronger shield law for abortion and gender-affirming care. Democratic Governor Maura Healey signed the SHIELD Act 2.0 into law Thursday. The bill further strengthens protections for patients and providers of reproductive health care, while explicitly mandating that abortions be performed when deemed medically necessary. And that is the kicker, and that's what people have been screaming. That abortion should be something, well, gender-affirming care as well, should be something that actual doctors have a say in. This isn't something that some schmuck across the state or across the country should have any voice in. The only people who should have a voice are the pregnant person, the doctor, possibly a spouse or significant other, depending on the situation. It could be something that was a one-night stand, or that in the meantime they had broken up. There could be so many factors. But a significant other, if they're in a good place with them, obviously. And that's pretty much it. And possibly other family members, depending, like I said, on the situation that this person is in. Maybe friends, maybe family. But nowhere does it say perfect strangers, because it's not their call. So just like any other medical procedure, if an abortion needs to be performed, it should be performed. And just because you find abortion icky, which, pretty much everybody does, nobody, goes, oh, goody, 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 I get to have an abortion. Not how this works. So, yeah. Just like any other medical procedure, it's icky and has to be done. And nobody is happy about this. Now, if the woman decides against the doctor's advice for whatever reason, that she's willing to stick it out, or she's willing to accept the consequences, like she ends up dying, or it could hurt her fertility, or the baby won't survive a week. If she's willing to go through that, then that's on her. But most people, depending on the situation, like the baby won't survive a week, probably would say, you know what? Yeah, I don't want to put the baby through that, or myself, and go ahead with an abortion. It could be that they have other children. She wants to be there for them. So, medically necessary, have the abortion. But again, it's the doctor who recommends, and it's the mother who decides whether she's going to follow that recommendation. Nowhere does in this is there room for lawyers or strangers who think they know better the situation than the woman does, and trying to guilt her into something because they assume that she just didn't feel like being pregnant anymore, or whatever bullshit the forced birthers have used to justify that they're being good people by trying to save the unborn child. Because, traumatizing a woman more than she's already, because she's already having to deal with a wanted pregnancy that she cannot carry to term for whatever reason. I'm not sure where traumatizing them even more qualifies you as doing a good deed. I really don't. But anyway, back to the article. Massachusetts will always be a state where patients can access high-quality health care and providers are able to do their jobs without government interference. And that's the way it freaking should be. Healey said in a statement, "From the moment Roe was overturned, we stepped up to pass strong protections for patients and providers, and with President Trump and his allies continuing their assaults on healthcare, we're taking those protections to the next level. No one is going to prevent the people of Massachusetts from getting the healthcare they need." The state's original SHIELD law, enacted by Democratic Governor Charlie Baker in July 2022, prohibits states that had banned the life-saving treatment from punishing those who travel to Massachusetts to receive it by preventing the release of information or the arrest and extradition of someone based on another state's court orders. The new law further prevents the disclosure of sensitive data, such as a physician's name, and prohibits local law enforcement from cooperating with other jurisdictions in their investigations. It also directs the Department of Public Health to create an advisory group to help guide businesses as they implement privacy protections for storing or managing electronic medical records. Okay, a lot to unpack here. Now, obviously, if people have a problem with these SHIELD laws, well, states' rights. It's been deemed that states should decide on their own whether they're going to make these medical procedures legal. So, just because something's a crime in your state, too bad. It's not everywhere. I mean, it's not like marijuana laws where you could buy marijuana across the state lines as long as you don't bring it back. Because once you bring it back, then you're opening yourself up to litigation. Nobody is going across state lines, bringing a doctor back and having an abortion in the state where it is illegal. So, yeah. So basically, unless you're going to tell your constituents that they're not allowed to travel, which, I'm sorry, what? So, yeah. Let's see, what else? And of course, we don't want physicians' names given to these states, because why would we put physicians in a position to be harassed by officials in this other state, like in Texas, where this physician I think she's also in Massachusetts, but I'm not sure, or New Hampshire, I can't remember, where she's being, threatened with an arrest in Texas for sending an abortion pill to a patient who happens to be a teenager. So yeah, why open doctors up to harassment or to arrest warrants when they didn't do anything illegal in their state? Anyway, and of course, why should local law enforcement cooperate with other jurisdictions when the laws are different? It's not like you're cooperating looking for a criminal, like a murderer or a robber, because those laws are across the country. It's not like some states have a law against murder, some states don't. Nope, not how this works. So yeah, that makes sense. Let's see. All right. Massachusetts is home to the best healthcare providers in the country, and we aren't going to let them be intimidated or punished for providing life-saving care, said Lieutenant Governor Kim Driscoll. Together with the legislature, we are reminding the entire country yet again that Massachusetts is a place where everyone can safely access the health care they need and deserve. Absolutely. So, and the same can be said for all of this, not just for abortion, but gender-affirming care. Because I know it's hard to fathom, but there are parents out there that actually love their children so much that they accept that their child is trans. And if they need to get gender-affirming care, and they have to cross state lines to get it, they're going to get it. Now, before people lose their shit about surgeries, no. If you're under 18, you're generally not having surgeries. Again, unless the gender dysphoria is really bad. So no. That's not happening. But there's other gender-affirming care that you can receive, like puberty blockers, and I don't know what else, because I'm not I don't work in a gender clinic. So all I know are puberty blockers. I don't know what else they could do. Possibly hormones. I don't know if that's something that they still do before 18, or if they only do that, like the surgeries, only if the gender dysphoria is really bad. That I'm unsure of. The only one I'm sure of is the puberty blockers. And if you're not going to provide gender-affirming care in your state, then I don't see what the problem is. Now, that's for children. For adults, because there's nothing that says this is only for children. And let's face it, the gender-affirming care laws claim that they're just protecting children, but a lot of these overshoot the child mark. And, adults, they need hormones, they need surgeries. If they have to go to Massachusetts to get them, I mean, good on Massachusetts, because this is something they need to survive. It's for their mental health. I do not understand why this is so hard for people. Anyway. So that is the end of that article. All right. So final one, and this is going to end on a downer. Which country is about to implement a nationwide transgender bathroom ban? So that's great. The United Kingdom's leading human rights agency is set to issue guidance banning transgender people from single-sex facilities, in some cases even those that match their sex assigned at birth. Which, I don't know, is this acknowledging that they're not the sex assigned at birth? Because why ban them from that space as well? The Equality and Human Rights Commission is expected to submit the guidance this month, according to The Times, in supposed compliance with the nation's recent Supreme Court ruling. The policy will impact trans people's access to bathrooms or changing rooms in organizations that provide public services, including schools, hospital wards, sports clubs, domestic violence shelters, prisons, charities, and some shops. Now, if all of these organizations had a family bathroom or some type of non-gendered bathroom, then there would be no problem. But that is not the case. Schools might have it, depending on the level. Hospital wards, they definitely have it. Sports clubs, possibly. Domestic violence shelters, most likely not, simply because domestic violence shelters are generally geared towards women. So they're probably not going to have anything but bathrooms for women. So I'm going to say no to that. Prisons, well, obviously they're not going to have a gender-neutral bathroom because, the whole point is there's the men's area, there's the women's area. So, no. I'm going to say no to that. Charities, maybe. And some shops, again, maybe. So what do the trans people do when they're in areas that don't have gender-neutral bathrooms, but they can't use gendered facilities? The draft also said that a trans person could be banned from spaces that do not match their biological sex, claiming a legitimate aim for excluding a trans person from a separate or single-sex service for their own biological sex might be to prevent alarm or distress for other service users, which is inherently claiming that we know that you look like the opposite gender. So you're acknowledging that they look and are the opposite gender. So why are we doing this again? A trans man might be excluded from the women-only service if the service provider decides that because he presents as a man, other service users could reasonably object to his presence, and it is a proportionate means of achieving a legitimate aim to exclude him, the guidance states. Okay, so if you look like a man and you're so much so that you freak out women if you go into their spaces, then what's the problem with them using the men's room? How is that a problem? Scotland, which is part of the UK but has a semi-autonomous government, passed a law in 2018 that all Scottish public organisation boards must have an equal number of men and women members. Trans women were included in the number of women board members if they had a gender recognition certificate. For Women Scotland, a right-wing organization dedicated to so-called women's sex-based rights, a dog whistle used by anti-trans activists to exclude trans people from public spaces and reduce women to their genitals, filed a lawsuit against the government challenging the inclusion of trans women. They initially lost their case in Scotland before appealing to the UK Supreme Court. And that is the irony. TERFs will scream that they're more than their genitals. But when it comes to trans women, all they care about is the genitals. I mean, pick a lane. Either we're not reduced to our genitals or we are. Pick one. The court ruled in their favor, determining that trans women aren't legally considered women under the nation's Equality Act. The ruling has already been applied by some agencies, including the Football Association, which banned trans women from playing women's soccer in May without mentioning trans men. Pride Sports, an LGBTQ+ sports organization, told the New York Times that there were fewer than 30 trans women playing women's soccer in England and Scotland, and they had done so without incident. But, we've got to cater to the pearl clutchers. However, the change to the legal definition of sex was only for the purpose of the Equality Act 2010 and does not permit harassment or discrimination based on the protected characteristic of gender reassignment, such as bathroom bans, according to LGBTQ advocacy group Stonewall Scotland. So, based on this, the law is unconstitutional. Okay. Stonewall Scotland denounced the EHRC's guidance in a statement released shortly after the policy was first proposed, saying that it risks encouraging organizations to implement blanket exclusionary policies, which will impact on trans people's rights to non-discrimination in enjoyment of their human rights and may open up litigation risks. As an organization that has long campaigned for equal rights for all LGBTQ+ people, we are incredibly concerned about the impact this guidance will have on the ability for trans people, as well as gender non-conforming LGBT people, to live their lives free from harassment and discrimination, it wrote. So that is the end of that last article, and like I said, we're ending on a bummer. I don't believe I have anything else to add to this that I haven't already said. So with that, I will see you guys in the next video.